All right, so let's talk a little bit then about primary and secondary liability for copyright infringement. So primary liability for copyright infringement, if we use our example again of you transmitting infringing material that you have created over the internet, you are directly violating one of the exclusive rights of copyright, which are found in Section 106 of the Copyright Act. So you're making a reproduction, you're making a distribution. So you would be directly violating those rights. Secondary copyright liability is liability for someone other than the direct infringer who is facilitating or making possible that infringement. And when we look at some of our cases in a moment, we'll see some of the details of what we mean by specifically by secondary liability. But just for our purpose now, keep in mind that someone like that internet service provider, someone like that YouTube who is making it possible for you to engage in the direct infringement under certain doctrines of copyright secondary liability could also be liable for copyright infringement. And of course, from the perspective of the owner of the content, especially if it's something like, a movie or a music file or some other content from a large media provider, it's going to be much more desirable for them to be able to go after that internet service provider or that YouTube-like provider because they're easier to identify, because they might have assets that are easier to get at, because they may even be cooperative and want to resolve the case, and because there might be large quantities of infringement going through some of those channels or pipes. So it's, from the perspective of the media owner, much better for them if they can go after that intermediary. Obviously, from the perspective of the internet and having an open, functioning internet that allows for user-generated content, it's pretty difficult to say that the intermediary should always be responsible in those circumstances, because what you'd really be saying as a matter of internet governance is that those intermediaries are responsible for policing copyright infringement. And if you get into those kind of circumstances, you may actually create legal barriers and economic barriers for the web to even work. So the international community recognized this in the WIPO, World Intellectual Property Organization, Copyright Treaty in 1996, and the United States Congress recognized it in bringing into a general provision of that WIPO Copyright Treaty regarding facilitating the internet and electronic commerce into the details of OCILA. We will also see that there are elements of the DMCA that involve copyright protection measures, technological protection measures such as encryption. Those are also part of the WIPO Copyright Treaty. Those are a key part of the WIPO Copyright Treaty. Those are also part of the DMCA, but that's not what we're looking at here. Here we're looking at these safe harbors. So I have here listed the four potential kinds of safe harbors, and we'll take a little bit more detailed look at those in just a moment. But notice that each of them, transitory communication, system caching, information that's residing on a system at the user's direction, those I think are pretty clearly part of the process or dynamic that I was just showing you a moment ago when we were reminding ourselves about how the internet works. This fourth one, internet location tools, sounds a bit odd, but really what it's about is things like hyperlinks, like ways of finding files on a site. Are you linking to another server, another site that might have infringing content? Now we'll look at some of the details of these safe harbors in just a moment. Notice that for all of the safe harbors, and each of these safe harbors has their own kind of requirements and limitations. Notice for that for all of these safe harbors, there's a threshold. And the threshold is, number one, that the online service provider has adopted a policy for termination of repeat infringers and is implementing that policy reasonably and is informing subscribers of that policy. And as we'll see in just a little while, there's plenty of litigation over when does the service provider have knowledge of repeat infringers, what kind of policy do they actually have to adopt. And then secondly, the service provider accommodates and does not interfere with standard technological measures. And this just means kind of standard measures that are taken by the copyright owner to identify and protect their copyrighted material. Okay, let's look in a little bit of detail in some of these safe harbors. And this is in 17 U.S.C. 512. So here is the first part on transitory digital network communications. And notice this deals with transmitting, routing, providing connections through a system or network. This is just what we were talking about in terms of how the internet works. So here are the requirements. The transmission is initiated by a person other than the service provider. So again, the subscriber sending the stuff over. The transmission is carried out through an automated process without selection of the material by the service provider. So in the ordinary course, you're sending an infringing MP3 file through a peer-to-peer connection to somebody else, and it's routing through your internet service provider. The provider isn't selecting that file. The provider just has ordinary protocols that all traffic uses. So that's what that provision is about. The provider does not select the recipient except as an automated response. So in other words, the provider isn't identifying who the recipient is. You, the sender, are determining who the recipient is. The provider is not making a copy of the material except for some kind of intermediate or transient period necessary for the transmission to work. So the provider itself is not storing in any kind of long-term storage the material. And the material is transmitted without being modified. The provider is not adding anything or taking anything away from the content. So in essence, Part A is just saying the internet service provider is simply acting as an internet service provider routing traffic, and it's allowing the provider to sort of be traffic neutral. Okay, system caching. So here we say the provider is not liable for material that is in intermediate or temporary storage. And again, this relates to the transitory digital network communications, kind of like a belt and suspenders. The material is made available by a person other than the service provider. The material is transmitted by a person other than the service provider. The storage is carried out through an automatic technical process, right? So once again, the service provider is just acting like a service provider, and the law is allowing them neutrally to do that. Notice also that there are a number of conditions for the system caching safe harbor under Section 2. And if you read through these, you'll see that they all relate to the fact that the service provider is acting simply as a service provider, is not selecting the content, is not selecting the user, is not using any kind of special technology, but is simply acting as a service provider. Section C is one of the big sections that there's been a fair amount of litigation on, and this is information that's residing on a system or network at the direction of the user. So notice that the first two sections are transitory. It's really things going through the network, and in many ways is kind of dealing with that first level of internet service provider. Now, materials at the direction of user is really dealing with what we today call Web 2.0, which is users generating content, users manipulating and using content that resides on the server, the storage of some service, like a YouTube, for example. So notice the requirements in Section C. The provider does not have actual knowledge that the material is infringing. And as we will see, this section is a section that has been and is being hotly litigated. So it does not have actual knowledge. in absence of actual knowledge, basically doesn't have constructive knowledge, is not aware of facts or circumstances from which infringing activity is apparent. And upon obtaining knowledge of infringement, the provider acts expeditiously to remove it. Also, the provider does not receive a financial benefit directly attributable to the infringing activity if the provider has the right and ability to control that activity. Again, as you might imagine, a hot issue that's subject to litigation. And third, upon notification, the provider acts expeditiously to remove the infringing material. And this is the notice and takedown procedure that we talk about in the context of the DMCA. The provider must have a designated agent who is available to receive the notification. This doesn't need to be sort of anything fancy. It just needs to be someone, an actual person who's able to receive the notice electronically. And then there are requirements in Section 3 for what the notice needs to contain, the notice that there is infringing material. And so you see the list of those elements here when you read the statute in that notice. So the fourth safe harbor is these information location tools. So notice information tools including directory, index, reference, pointer, or hypertext link. And again, there's actual knowledge, there's constructive knowledge, and there is a duty to remove. And again, there is the requirement that there's no direct benefit where the provider has the right and ability to control. And again, there's a notice and takedown. So both as to stored content and linked content, very similar kinds of features.